Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Palomo, where we discuss all things estate planning and elder law, and well, hey, anything else we want to talk about. Today is going to fall squarely under the estate planning and elder law category, as we are going to be talking about planning for individuals with disabilities who are receiving public benefits. So if you have a child who has a disability and they're getting public benefits, this is a podcast or a show you want to listen to. If you have a family member, or if you just want the information to understand the planning opportunities, this is the show for you. Now, before we get into the actual podcast, of course, I want to do our disclaimer. Please do not take anything that you hear from this show, or any other show for that matter, to constitute legal advice. If you are looking for legal advice pertaining to a specific situation, please contact a lawyer licensed in the state that you reside in, who practices in the area of law that you are looking for advice in. And once they meet with you and understand the facts specific to your case, they can give specific advice, which will constitute legal advice. This show and any other show is for informational, educational, and entertainment purposes only, and specific legal advice should not be taken from this specific show. But we will certainly give a heck of a lot of education and a lot of wonderful information. At Palomo and Associates, we offer free educational workshops in estate planning, crisis Medicaid planning, life care planning, as well as administration after the loss of a loved one in both probate and trust administration, and finally, special needs planning. This podcast is going to be specifically around the special needs planning arena and the techniques that we can use in that context. All right, looking forward to it. This is going to be a great topic. I've actually been getting a lot of emails and requests for a podcast on this topic, which is why I am doing it. So if you have any suggestions for a podcast that you would like to hear, please send me an email. Reach out to the law firm. Let us know. It would be a lot of fun for me to do what you guys would like to hear. So we will certainly get that done as soon as possible. And here we go. We had a request for special needs, and we will take care of that today. First things first, I just want to give a brief overview, just a kind of big 3,000-foot view of kind of estate planning in general. We always talk about the different documents that are typical in a common estate plan. We have a financial power of attorney, a document that authorizes someone to make financial decisions if you are not able to, a medical power of attorney for medical decisions if you're not able to as well. And within the medical power of attorney, there is going to be a living will, which will make it an advanced healthcare directive because it is a medical POA and a living will together in one document. The living will component will tell us if you are end of life, if two qualified physicians say that there is no realistic hope of recovery, whether you want heroic and life-saving measures or whether you want them to withdraw treatment. As well as a last will and testament, a document that will say, if I have assets in my name alone at the time of my death, where would I like those assets to go? Who would I like to receive those assets? And how would I like them to receive it? So those are kind of the basic documents, as well as in a lot of our planning, you will hear us talk about trusts. Trusts are a legal contract between three parties: the grantor, the person who creates it; the trustee, the person who controls it; the beneficiary, the person who receives it. Those are the general sort of overview of estate planning documents from a 30,000-foot view. Now, specific when we're dealing with individuals with disabilities, it's important to remember that when you turn 18, the law presumes that you have capacity and that you are able to make decisions for yourself. So when a child turns 18, we want to make sure that we get that financial power of attorney in place, that we get the medical power of attorney in place, so that if something were to happen, or if the individual was not able to make decisions anymore, another person, probably in this context, it would be the parents if they're still alive, would be able to make decisions for them. When we're dealing in the disability context, sometimes individuals who turn 18 do not have capacity. They do not have the ability to make decisions for themselves. They could not meet with a lawyer and explain to the lawyer generically who they are, what type of assets they have, who do they want to make decisions, have an understanding of what it means to have someone else make decisions. If they do have that capacity, then we're going to want to get a power of attorney in place when they turn 18 or as soon after as we can. If the determination is made by the lawyer that they do not have capacity to sign a power of attorney, and there is not a way to get that document in place, then it would make sense to go to a guardianship hearing, which is a legal court proceeding that a petition has to be filed, the citation has to be served on the alleged incapacitated individual, and there has to be a hearing in regards to whether or not the child has capacity or is incapacitated, and therefore a guardian needs to be appointed. But I always like to start with the guardianship statute is very clear that a guardianship is a measure of last resort, meaning they want us to try a power of attorney first. They want us to see if the individual has capacity to do that. In fact, most courts now are even asking it in the hearings and in the process because that is the first step. So we do want to see if we can get a power of attorney in place if the individual does have capacity. Now, on this podcast, I'm not really going to get into the capacity piece. That's a legal determination that it was made by a lawyer to determine if the person can do a power of attorney. I don't want to bog down this podcast. I really want to get into the special needs planning opportunities that are available. But I did want to cover, at least briefly, that a lot of times when we have disabilities with a child, it's important to see if at 18 we can get that financial and medical POA in place. Because remember, just because you're allowed to do stuff when the individual turns 18, that very well may be because you're local, the hospitals know you, the hospitals know the situation. We have had a lot of cases when people go to other states for vacation or go to other places, and now they don't know who they are and they don't get away with some of the same stuff they got away with locally, and now decisions can't be made, money can't be accessed. And so it is oftentimes a very good thing to have that in place if you can do it, and if not, then the lawyer can certainly discuss guardianship. If you're not in the state of Pennsylvania, you might hear it called a conservatorship. There's different words for it in different states, but the concepts are generally the same as it relates to having decisions made by other people as to whether or not you have to go to a guardianship hearing. So I wanted to start there to just kind of give a high overview. Now what we're going to talk about is if you are a parent or a grandparent or an aunt and uncle and you want to provide for a family member with a disability, and if you know that they are receiving public benefits can be SSI, can be Medicaid, they can be on a Medicaid waiver program. I mean, there's all kinds of public benefits programs that are needs-based, some are income-based. Those are basically the items that we are talking about. We don't want to have a situation where a child with a disability receives something and then gets disqualified from benefits. So if you're going to provide for someone in your family with a disability who is receiving public benefits, you will want that money to go into a special needs trust for their benefit. And in this context, because it's being created by someone other than the child with a disability, it will be called a third-party special needs trust. A third-party special needs trust means that the trust was created for the benefit of somebody by someone other than the individual or by a third party, right? That's why it's called a third-party trust. You can do that in your estate planning. You can do that in your will. You can do that in a trust. You can do it in a trust that is created during your life, and then it sets up for the special needs trust. You can do it at your death in a trust, so that the special needs trust is created at death. there's all kinds of flexibility as to when you can do it and how you can do it. But the bottom line is the money will be given to the individual with a disability in a special needs trust called a third-party trust. This will allow the individual to receive the money during their lifetime, and then at their passing, the money can then go to whoever the testator or the person who created the special needs trust on behalf of their family member, to whomever they want it to go to after the individual passes. So for example, if my dad were to create planning for me as a child with a disability, he would do that in his estate planning. It would come to me in a special needs trust. I would have access to it during my life. But at my death, my father would be able to decide where it goes after my passing. The money that my dad gave to me never touches me. It never goes into my social security number, and therefore I never have access to it, which means I can get it, but I don't own it. It's not in my number. It's not in my social security number. While I can still access it through the trustee of the special needs trust, it's not counted against me because it never touched my social security number, and therefore my public benefits will remain. So that's a great tool for family members to make sure that they take care of loved ones with disabilities. It's very important not to leave money outright to an individual with a disability. And by outright, that could be because you own an asset joint with them, you have them listed as a beneficiary on accounts, you have them listed in your will, you have them listed in your trust. If the distribution is outright to an individual with a disability and they're receiving public benefits, they will lose those public benefits. So the third-party special needs trust is what allows family members to provide for an individual with a disability and still get access to the money, still get to spend the money, but not lose their government benefits. All right, so that is a third-party trust. Great tool, great opportunity for family members to provide for loved ones with disabilities and still allow them to keep their government benefits and get access to the money through the trustee. I mentioned the definition of a trust earlier, a legal contract between three parties. One of the parties was the trustee, is the person who controls it. So the trustee will be somebody other than the individual with a disability, and that person can distribute money on behalf of the individual with a disability to assist them in their lives, to enhance their life. The statute or the case law, it's called the Lang decision, L-A-N-G, basically says that the money in a special needs trust has to be to supplement, not supplant, the government benefits. Meaning, the government will provide for the necessities of life, and the special needs trust can provide for everything else, for anything else. Vacation, vocation, horse therapy, rehab, TVs, extra items, fun stuff. That is all okay to pay out. And now, even under SSI, it can pay out for anything other than shelter. Years ago, it was anything other than food, shelter, and clothing. And then over time, SSI has been sort of eroding that away. And now, at this point in time, it can be paid out for anything other than shelter and utilities. And they won't even have a reduction in their SSI benefits. So that's a great benefit. As far as Medicaid goes, we don't have any issues there either. So they'll still get to keep all of the Medicaid and SSI benefits, and they can still get access through the trustee of the trust. All right, so now I'm going to change sort of the fact pattern. I'm going to change what it is that we're talking about. Now what we're talking about is Jeff is the individual with a disability. Jeff is receiving public benefits by the government. Jeff works. Jeff receives an inheritance. Jeff gets a settlement, a personal injury settlement, right? Now notice the commonality of all of that. Jeff is receiving the benefits. Jeff has this money coming to him now one way or another, whether it's through work, through inheritance, through a settlement. It touches me. It goes into my social security number. I now own the money. Most of the government programs that we are talking about with SSI and Medicaid have a $2,000 threshold that the person is allowed to have no more than $2,000 in their name and still receive the benefit. So what that means is I'm going to go over $2,000 if I receive an inheritance, if I get a settlement, if I work and I'm able to accumulate enough money to go over the $2,000 threshold. But the government benefits that are being provided to me are huge. There are great benefits that are being provided to assist people with disabilities, and we don't want to lose those. So I am allowed at this point, instead of losing the government benefits, to create what is called a first party special needs trust, also known as a payback trust, also known as a D4A trust. All of that means that, yes, during my life, I can have this money go into a first party trust. I can even create that trust now as the grantor, or a parent or guardian can create it, but I cannot be the trustee. Somebody else will have to be the trustee, the person who will control it or give the money to me. And then here's the big difference. At death, the state of Pennsylvania has a right to get paid back up to the amount of care that was provided during life. So what that means is, in the third party context, my dad was able to decide that if I passed, the money would go to someone in the family. That money never touched me. This money is mine in the first party context, which means it already touched me, it's mine. So instead of losing government benefits, I'm going to go ahead and create a first party trust, get access to the money during my life, but at my death, the state has a right to get paid back up to the amount of care that was provided. So just a fun little tip. If there's a situation where there is a first party trust and a third party trust, always spend the money from the first party trust first, because that has the payback provisions. That has the rights for the government to get paid back. The third party one that was created by someone other than me does not have to get paid back, so therefore you don't want to spend that first if you don't have to. All right, great benefit again, keeps the benefits of the individual. The money was already received, right? It was a situation where I was listed as a beneficiary on an account. It was a situation where I received an inheritance, I received a settlement, whatever. I went over 2,000. Instead of losing the government benefits, I create, or a parent or guardian creates on my behalf, a first party trust. Now, there is some approvals that have to be done. The attorney will get approval from the state that the trust looks good and that the language is correct. Not a hard process, but certainly a step that must be accomplished. And then once we take care of all of that, we can go ahead and get it funded. All right, so that's the first party special needs trust. It has to be created before your 65th birthday. And there's also another animal that is very similar to this called a pooled trust. Pennsylvania allows a pooled trust that also must be funded before 65. And the only difference between the first party trust and the pooled trust is that in the pooled trust context, you're using a charitable organization. They will have a fund that will, a pot of money, the pooled trust that will be pooled for individuals with disabilities of the same type. So during my life, I can still get access to it through the trustee. But at my death, instead of it going to the state with payback provisions, it will remain in the fund for the individuals with similar disabilities to me. So also a very great benefit. The federal statute doesn't have a limitation on the age restriction, but Pennsylvania is saying that any transfers after the age of 65 will not be considered transfers for fair market value, and therefore a penalty is assessed. So essentially, you're going to want to do that before the age of 65, the same as you would with a first party special needs trust. Now, if for some reason you can't create them because you're over that age, contact an elder law attorney. There are still other planning techniques that we won't talk about on this video Those will be discussed in our crisis or Medicaid planning, which is a completely different context if you're over 65. But if you're under 65, you can still fund a first party or a pooled trust in order to be able to protect money that was already received by me. It already touched me. It already touched my social security number. Now what I'm trying to do is just keep the benefits so that I keep getting the benefits, but I do get access to the money during my life. But when I die, in the first party trust context, the money gets paid to the state of Pennsylvania. In the pooled trust context, it stays in the pot for the group of individuals with similar disabilities. All right, now, within the last few years, there has been another animal that has been brought into the context, which is called an ABLE account. ABLE account were created federally. Pennsylvania adopted it. It is a wonderful opportunity for individuals with disabilities to still set up an account that gives them access to it, allows them to remain on government benefits. But the ABLE accounts are a much cheaper, more inexpensive way than having to set up a first-party special needs trust. And it still allows them to get access to the money for qualified medical expenses, which is arguably a little broader of a term. The only downside with ABLE accounts is that you can only fund up to the annual exclusion amount that is applicable in that year into it in 1 year. So currently, it's an $18,000 annual exclusion amount, which means you could only fund into the ABLE account $18,000 a year. So that could work great if I, Jeff, am working and I have a disability and I'm receiving public benefits and I earn enough money to get over $2,000, but I don't earn enough money to have to deposit $18,000. So every year I could just use the ABLE account. Very inexpensive. The website, paable.gov, is a phenomenal website that allows you to see everything about ABLE accounts, who can set them up, how they can be set up. They're very simple. You can even do it online. Tells you where you would go to open the bank account for the ABLE account. The only real limitations are a couple. One, the onset of the disability has to have occurred before it was 26 years of age. It is going to 30 years of age, so that the onset of the disability has to have occurred before that age. And you will not have an impact on your SSI benefits until that account generates over $1 million. And you will not have an impact on your Medicaid benefits. The number is over $500,000. When you're only funding at $18,000 a year, getting to $100,000, if I said $1 million, I apologize. Getting to $100,000 or getting to $500,000 it would take a lot at $18,000 a year. Great benefit, great opportunity, inexpensive, easy to do, easy to have access through a person who will act as a trustee. But the statute does say that if there's any benefits remaining, the state can get paid back up to the amount of care that was provided. Now, my understanding is that currently Pennsylvania is not going after those funds in a state recovery. They're not going after those funds and making the payback occur. But it absolutely says they can in the statute. So generally speaking, when we're giving advice to individuals who want to provide for a loved one, we're not typically having them put the money in the ABLE account. We're having them put the money in a third-party trust. Remember, with a third-party trust, there is no right for payback. So this is where we're definitely seeing some people crossing terms and getting mixed up a little bit. I do see a lot of parents and grandparents creating these accounts. My fear is that if Pennsylvania changes administrations, they very well could change the position. And because the federal position says, or statute says, that states can get paid back up to the amount of care that's provided if there's any money left, that sounds an awful lot like a first-party special needs trust. So the context that we're setting these up in is if the individual with a disability goes over the $2,000 amount, my money, it comes to me, it touches my social security number, and I want to be able to stay on those benefits. But the amount that I would have to fund is less than $18,000. I'm using ABLE. I'm not using them personally in context for other individuals to fund. I'm having them do that through third-party trusts so that there is no payback provisions. So certainly ABLE has a wonderful place. It's a very valuable tool. But if the amount that you would need to protect is over 18 grand, you're going to be looking at the first party and the third party trust options. Again, with first party and pooled trust, they have to be under the age of 65 to fund them. If they're over 65, they can't use the first party and pooled trust in Pennsylvania. If the amount that they're trying to protect or the amount that is in their account is over $18,000, they're going to use the first party or pooled trust option. If the amount is under $18,000 in a given year, then they will go ahead and use ABLE. You can have an ABLE account as well as a first party trust. That certainly is allowed. So there can be a mixture of both. But generally speaking, a lot of people will pick which one they're able to use depending on the amounts. So that was special needs planning in a nutshell, right? In a pretty quick format. But the highlights I just want to kind of reiterate. In the context of an individual turning 18 years of age, we want to see if we can get a power of attorney in place. If not, because they do not have capacity to sign a power of attorney, they met with an attorney. The attorney said they don't have legal capacity. Then we'll go through the guardianship hearing. The guardianship hearing is the option for allowing another individual to be the guardian, allow the decisions to be made for that person. If we have a person who is receiving public benefits and they are given money by someone other than themselves, if they're going to inherit money, if someone wants to give them money, aunt, uncle, grandparent, parent, they're going to create a third-party special needs trust that will allow the individual with a disability to continue to receive their government benefits, but also get access to the money, and it will not lose anything. And at their death, the person who created it, the parent, the grandparent, can decide where they want the money to go after the death of the individual with the disability, presumably maybe to another family member. If the money already touched me, the individual with a disability, whether it be because I received an inheritance, a personal injury settlement, or I work and I went over the $2,000 threshold for SSI and Medicaid purposes, now I have to do something to maintain those public benefits and not lose them because I went over $2,000. If the amount is less than $18,000 in a year, I'm going to create an ABLE account. The website is paable.gov. Great website, great resources that will allow me to maintain my benefits, still get access to the money. If the amount is greater than $18,000, now I'm going to be looking at a first party special needs trust, and that will allow me to keep my benefits, get access to the money through a trustee. At death, the state of Pennsylvania has a right to get paid back up to the amount of care that was provided for my benefits during my lifetime. And if I am under 65 years of age, I can use a first party trust. I could also use a pooled trust if I'm under the age of 65. And the only difference is at my death, instead of the money going to the state up to the amount of care that was provided, the money will go to the charity to benefit individuals with similar disabilities after my passing, instead of it going to the state of Pennsylvania. A lot of charitable organizations have those pooled trust accounts. Also, you want to create that before you're under age 65, particularly in Pennsylvania. Federally, it appears to be allowed, but Pennsylvania does say if you're over 65, it is not considered a transfer for fair market value, and a penalty is assessed. So we do want to be careful of that and watch that as well. So that is special needs planning in a nutshell. I hope you enjoyed this show. I can't thank you enough for being here. If you're looking for more information, please reach out to the office at 717-845-5390. Check us out on the web at www.bellomoassociates.com. That's B as in boy, ELLOMO, associates.com. Thank you for joining the Red Wagon Estate Planning and Elder Law Show. Until next time, we'll see you real soon.